Hello, everyone. I'm Preeti. I'm the registered migration agent from Aussie's Group, and today I'm going to talk about the employer-sponsored visas. So, for the employer-sponsored visas, the main visas which I'm going to cover today is the Class 482, ENS 186 visa, 494, a regional employer-sponsored migration scheme, training visa, and designated area Dharma visa. So all of these visas have got one thing in common, which is that you all would need an employer to sponsor your visa. If you do not have an employer, then none of this visa can be worked out for you. For the first of all, I'm going to talk about the 482 visa, which is a skill shortage visa. It's quite good at the moment. The processing is quite fast at the moment, and the approval rate is also quite high. This visa is up to the 4 years for which you need an employer and has got a three-stage process. Mainly, most of the visas are either the two or the three-stage processes. This visa has got a sponsorship, the nomination, and the visa application. First, I'll talk about the sponsorship. So for the sponsorship, it is the standard business sponsorship that either the employer needs to have it for the 5 years, or if the sponsorship, and it's a one-time process. For this, you do not need to get it again and again with each application. Once you have got your sponsorship approved, that's valid for 5 years. You do not need to get it renewed, done it again when you're launching a nomination or a visa application. The requirements of sponsorship are the mainly is about that the business should be actively and lawfully structured in Australia and should be working. The employer's obligation is to meet SAF levy, is to cooperate with the inspectors and the employment terms and conditions. We have seen a lot of employers where, in a lot of applications, where the department has approved the sponsorship, the nomination, and the visa. The applicant is working also. And then there have been the investigation that has been conducted where the applicant must go and the employer must provide all the details of what has been asked by the officer. If the obligations are not met, the visa can be cancelled, which has been granted earlier. Sponsorship requirements, again, we continue with that the business must be lawfully operating. You need to meet the training requirements, which is the SAF levy, have no relevant adverse information about the company, and the business must demonstrate the commitment of employing the local employees. Though there is no such requirement that if you do not have an Australian employee working, then you cannot sponsor anyone. But it is the requirement that you have to show that you do all your efforts as an employer to employ the Australian employees, which is the LMT. Then comes the nomination. Now, once the sponsorship is either approved or has been applied for or is already in place, which is there for the 5 years, then the employer has to go with launch the nomination application. Then you must have either the approved employer, or your sponsorship application is ongoing. You need to have an eligible occupation. The nomination for a 482 is done from a couple of different lists. There is a 482 long-term list, there is a 482 short-term list, and an ROL. So you need to have an occupation from one of those lists, and you must advertise the position for at least for 28 days, out of which, and in the three mediums. One of them is the job active, that must be done into that, and two more mediums, which is either your can be Seek, can be Indeed, can be any of those ones. There has to be the genuine position, that if the company is, for example, it's a restaurant manager and you are doing it for an office manager, and it is into the hospitality industry, then it is very hard to show why an applicant or why the employer needs a restaurant manager. So it must be genuinely required by the company. Market salary rate. The current market salary rate until the 30th June is 53,900. However, that is also known as the TISMIT. The TISMIT is going to increase by 70,000 from 1st of July. If the nomination application has been lodged before 30th of June, And eventually, after 30th of June, if the visa is being lodged, then the new testament requirements does not apply to the old nomination, which is lodged before 30th of June. So if you have got an employer where your nomination is just about to be lodged and the LMT is completed, where you have advertised your position for 28 days, then you should look into lodging your application before 30th of June 2023, because the testament is increasing. The testament is something which your employer needs to offer you as an employment contract of the minimum that salary. There does not has to be any adverse information about the employer. That goes for all the sponsored visas applications. Now we talk about let's say that the nomination is lodged. Now we talk about the visa requirements. As for the visa requirements, you need to be either the nomination to be lodged, your SPS to be approved, or SPS to be lodged. All of these three applications can be lodged at the same time, though the SPS will be lodged first. The TRN number of an SPS will be used in the nomination, and then the TRN of a nomination or a reference number, the TRN is considered as a reference, is to be used in the visa application for a lodgement. So if your visa is currently expiring and you are in a rush of the lodgements, you can lodge all three applications within the same day. The applicants needs to meet the required skills and qualification requirements, need to have an English requirement, health and character, and there is no minimum age requirement for this visa. Let me talk about the skills and experience requirements. For the 482 visas, the minimum skills are required are 2 years of a full-time experience. The experience cannot be casual. It has to be the full-time experience which the applicant is having. Whether that experience is in the concurrent of the education that you are holding, it's fine. So let's say that I am going to do an application for a chef and you have got 2 years experience as well as the certificate 4, which is the minimum requirement for this application, and your experience is in concurrent, you are fine for lodgement of a visa application for this. It does not have to be the post qualification for this. Once your visa is granted, then it is the requirement of an applicant to stay with the employer for the terms of the visas, which is that if the visa was for 2 years, 3 years, or 4 years, you have to stay with the same employer and be regulated in the same salary, what is being approved in your nomination. The nomination is valid for 12 months, so your visa must be lodged within those 12 months, if not lodged at the time of a nomination. If there is any license requirement which needs to be held for the visa applicant, then it is mandatory for the applicant to hold that license also. So now here we are talking about the visas, that the terms where the short-term visas are granted for. If your occupation is from a short term, it is granted for 2 years. If your occupation is from a long term or from a labor agreement, then you are, or an ROL for an instance, then it is granted for 4 years. The short-term visa, the applicant chooses an application. So what is the difference between the short-term and the long-term? The applicant chooses the requirement, the occupation list from the STSOL, which is the short-term visa. There was a major difference between the short-term and the long-term, which was that the short-term applicants does not lead to the permanent residency of its own. Then the applicant has to look for the other options. However, from the December 2023 onwards, the short-term visa holders can apply for the permanent residency once they have worked with the employer for the 2 years. So the major difference between the two has been gone at the moment with the COVID into the one and with the new legislations that's coming up. Then again, for the long-term visas, it is for the 4 years, and you are eligible for 3 years. After 3 years, depending upon your age, English, and character requirements, because after 3 years, you still have to meet the requirements of the visa for a 186 that you are lodging under the TRT stream. However, now from the December 23 onwards, you are eligible to apply for this after just holding 482 visa for 2 years. Now, the labor agreement. Now, this is another stream. Why do we need a labor agreement, or under what instances you need a labor agreement for people to apply for? Is because when you do not have an occupation in a short-term or a long-term list, then you need the labor agreement for which you are going to negotiate with the department that why the occupant is required or the applicant is required in this industry. And then once the number of occupations are negotiated, then you can lodge the nomination and the visa. So the SBS requirement is not there under a labor agreement. You have to get the labor agreement approved. Like in the 482 with the short term and a long term stream, you do not need for the SBS to be approved to lodge the nomination or the visa. However, under the labor agreement stream, once you lodge the labor agreement, you cannot lodge a nomination unless until your labor agreement is approved. And the conditions of the labor agreement depends upon the way is varying from one application to another. In one application, the English requirement can be 5, and in the other application, the English requirement can be 4.5 or can be waived also, depending upon how you had negotiated with the department for the labor agreement nomination requirements. Now, we do have generally these questions that does the 482 leads to the permanent residency? Yes, it does. And now there is no difference between the short-term, long-term or the labor agreement for leading to the permanent residency. It can be lodged right after the 2 years of holding a 482 visa. And also, once we are this comes under the obligation of the of holding as a 482 visa, as the current requirement is that the applicant must only be working with the current employer only. However, from 1st of July onwards, the people they're talking about that it is going to change to the 60 from a 60 days. If in case you are not working with your employer, then the requirement currently is 60 days, and within 60 days you have to lodge a new nomination. And while your nomination is not approved, you cannot work with your new employer. However, that is being talking about that it is going to change it to the 6 months, and during those 6 months, while you are looking for a new employer, the applicant should be able to work in any field with another employer also. These changes are not legislated yet. These are upcoming changes, and we will let you know once it comes into the legislation. As we said, there's an extended pathway for the permanent residency under this one. By the end of the 2023, the TRT stream for the visa holders for the 186 is reduced from the 3 years to 2 years, and removing the limits of the number of short-term visas. So if you are holding a 482 visa for 2 years, earlier the requirement was that you cannot do the visas third time onshore, but now there's no more limits onto this one. You can lodge any number of visas of holding a 482 in the short term, as long as you genuinely meets the requirement of that visa application. Raising the TISMIT, as I said, that the TISMIT is being increased from 53,900 to 70,000 from the 1st of July. These changes are legislative, and that is going to come into an effect. So any application which are lodged before the date is all good to have to remain until 53,900. Whether your application is still under processing and not approved post 30th June, you're still fine for that. So basically, when talking about the whole process, it is that you have to apply for a SPS or a nomination, then you apply for the SPS, then the nomination, and then the visas, and that's how the whole chart comes into the effect. Now we talk about the 186 visa. 186 visa is directly a permanent residency. And there are two types of 186 visas. One is direct entry, and the other one is the TRT. So there is an age limit for a 186 visa. For example, let's say that I have lodged a 482 visa and I am 45 years old. Now, when I'm applying for the 186, and if I've crossed the 45 years of an age, then there is no age exemption, whether even if I hold the visa for 2 years and eligible for the 186 under the TRT stream. Still, you cannot apply for this because the maximum age limit is for this visa is 45. So 186 visa, now we talk about the streams, the direct entry, the TRT, and the labor agreement stream. Under the direct entry stream, the applicant who are not holding any 482 visa can apply directly with the employer for the permanent residency. It is not necessary for an applicant to be working for 2 years to apply for the PR, because that is the TRT stream where you should have worked with the employer for 2 years. Now, let's say that you want to apply for a 186 visa. All you need is the occupation in the 186 list. You must have a full skills assessment in your nominated occupation. You need to have a 6 each in English and 3 years of work experience in your closely related occupation. So if you're applying as a chef, you have got a 6 each in English, you have got a full skills assessment, then there is no need for you to apply under a 482. If your employer is happy to sponsor you for a permanent residency straight away, then you can apply for the 186 visa under the direct entry without working with that employer. That 3 years experience can be onshore from any Australian employer or from offshore, it doesn't matter. And also that experience needs to be post-qualification, unlike the 482. So, and must have a skills assessment, yes. The department has also announced that AFRA-regulated occupations, for example, we have got a nurse, or we have got a psychiatrist, or we have got the general practitioner. All of those ones, if they are holding a provisional registration, though they have got a full skills assessment and they have got a 3 years experience and meeting other requirements, then they are eligible to apply for the 186. However, in the 186 visas, it is mandatory to have the full skills assessment, as well as the registration license also is mandatory. Though they have just said that it is only for the registered medical practitioners. But if I'm an electrician and if I do not have the full if I've got a limited registration, we cannot apply. It's only been exempted for direct entry under these visas. So 186, we have talked about it. Now we talk about the 494 visas. So 494, it is a regional visa where your employer must be from a regional area, so they need the RCB to be approved. RCB criteria is meeting the market salary rate, which currently is $53,900, and eventually it is going up to $70,000. For a 494 visa, why do we apply for a 494 visa and not the 186? They both are the permanent residency. 494 apply leads you to where you have to work with your employer for the 3 years. However, in a 186, the employment contract is for 2 years, and then this is just an obligation. However, in the 494, you must, though the requirements of having a 6 each in English, a full skills assessment, and 3 years of an experience is same. So why somebody would apply for a 494 and not for 186 is because the occupation list. The 494 occupation list is quite long, and it covers almost most of the applications or most of the occupations. And 186 has got a very limited number of occupations where you can apply under the direct entry. So after the 494, you can apply for a 191 visa, though in the 186 it's directly the residency. So 491, you have got a 494 visa. You have to work with your employer for 3 years and have a taxable income of $53,900 or whatever was approved in your nomination, and then you can apply for your 494 visa, 191 visa. You can add the family member in your 191 at that point of time. The member needs to be in the part of your 491 and needs to be at least 23 years of an age, not beyond that. Benefits of 191 is you can work and study, you can sponsor, you get the Medicare benefits as in for all the permanent residents, we have it. After the 494, we talk about the training visa, which is the 407 training visa. This is a visa where the applicant only needs to have the obligation. The SPS is required. This is exactly the same. In the nomination, they have to show that the applicant is not fully trained or not fully skilled yet, is still we're going to work under the direct supervision of an employer or any other employee which has got a similar skill set in the same recognized field, and the training visa can be up to the 2 years. So generally we do a training visa for 1 year where we show that applicant is going to learn the skills for the another 1 year. To be eligible for a training visa, the applicant needs to be either have 2 years of an experience or sorry, either need to have a 1 year of an experience or have completed a study within the last 2 years in the same field. So for example, I have done a commercial cookery, and for some reason I was not able to do the job ready program, or I could not apply for a job ready program. At that point of time, I only have got an employer for sponsorship. So if my studies are completed within the last 24 months, then I can apply without an experience for a training visa, gain the experience, and then further can apply for different other visas according to the eligibility that I would be getting into. You need to have an SPS for this. You need to have a training plan, which is the requirement of a nomination. And there is no TISMIT that is being applicable on training visa. The employer does not need to pay you the TISMIT level salary. They can pay you as an apprenticeship also, or can just give you the accommodation and other benefits, and can be without the pay either. The requirements of the sponsor is exactly the same that we have for an SPS qualification, SPS application, which is actively working, actively employed in Australia. Now we talk about the labor agreement for the 482 stream, where the labor agreement, where, as I said, first, we have gone with the 482 visa, where the occupations are in the list. Then we talk about the 407 visa, where we do not have an experience, but we do have the occupation in the list. But what we should do when we do not have the occupation under any stream, then your employer can still sponsor you, but they have to negotiate the labor agreement with the department and negotiate the skills and experience required. For a 482 visa, we have got a standard requirement of having the skills and experience, as well as the English and character. However, under the labor agreement, the character requirement would still be the stable. English and skills and experience requirement can be negotiated. It can be up to the 1 year or education or experience, depending upon what do you negotiate with the department. Other than the labor agreements, which you do negotiate with the department, there are few labor agreements which are industry specific, which are already negotiated their requirements of what an applicant's age should be, what an applicant's education and experience should be, and those are called as industry-specific labor agreements. You all must be hearing a lot about under the aged care, that now there is a PR under the aged care, and this is what it comes into, because it is industry-specific, where the skills and experience has already been negotiated, and the applicants can apply for permanent residency, which is the 186 or 482 under the labor agreement straight away. They do not have to negotiate with the department. The requirement for these ones is that the aged care worker, nursing support worker, and personal care assistant workers can apply for these ones. The skills and experience that is negotiated is different for both the visa subclasses. We have got a 482 visa as well as the 186 visa. For a 482 visa, the applicant needs to have either the Australian study, which is the certificate 3 in aged care or personal support, or need to have a 1 year of an Australian experience to be eligible for 482 visa. It is not the requirement that applicant must have the study as well as the experience. It is all. For a 186 visa, applicant needs to have a study plus 2 years of an experience. And once they have got this as an Australian education and Australian experience, they can apply for the 186 permanent residency straight away. The employer does not need to be the same. For example, I have got my 2 years experience from XYZ employer, and now there is an ABC employer who is happy to sponsor me under an aged care or a personal worker. That's fine. We can be employed. The employer needs to give you an employment contract for the next 2 years and have to show that the position is available for you for the next 2 years. rather than the industry specific, the labor agreement also comes under the DAMA stream. So under the DAMA, these are the regional areas where it is already the requirements of the skills and experience has already been negotiated with the department, and every region has got their own DAMA specific requirements. Currently, there is a DAMA in Adelaide, in Queensland, in Victoria, in Northern Territory, in Western Australia, South Australia, Queensland. We have got a lot of DAMAs over there, and their requirements are according to what the designated area of theirs, which is the endorsement with the local requirements that they have already negotiated with the department. You need to meet those ones. In general, those requirements. Why? In general, those requirements are always talking about the negotiated age, education, and experience requirements, because department tries to boost the people who have got a lesser experience but happy to go to the regional area and work for the regional employer. And that's why DAMA has come into the place. Why not DAMA? Because firstly, it has got the eligible to the people where the occupations are not in any other list. For example, we talk about a retail supervisor. It's not in any list, but in most of the DAMA list, it is there. Applicant needs to have a less number of education or experience, which is already negotiated with the department. It leads to the permanent residency. Currently, the requirement is that you have to be a holder of a 482 visa for 3 years to go with the DAMA, with the 186 under the DAMA, right? Under the labor agreement stream. But that is going to change from December onwards for 2 years. So it is a great pathway for somebody to apply for a permanent residency. If they go through the DAMA, they only need lesser number of education or experience or skills and education. They have got the reduced English requirement, and then now further PR can also be lodged by holding a visa for 2 years under the DAMA stream. So the steps and the process of applying under the DAMA is exactly the same what we have in any other DAMA stream, but instead of the labor agreement, we go with the endorsement. First, we go to the designated area representative and get the endorsement done. Once the endorsement application is approved, which is with your local shire, then we apply, then we take that approval letter to the Department of Home Affairs and apply for the labor agreement. The conditions of the labor agreement, and that's already negotiated. So we just need to meet that, the labor market testing for that one. Once the labor agreement is approved, then the nomination and visa can be lodged. Again, under the DAMA also, if you have got any of the employers where they have where the labor agreement is under the processing, the nomination cannot be lodged. For every labor agreement, whether it is an industry specific or whether it is an DAMA, under the DAMA, or you are going to negotiate under the normal stream for a labor agreement, needs to be approved first before the nomination can be lodged or before any visa can be lodged. So I'm going to wrap up all the visa requirements currently again for starting from the 482 and ending up to the 186 visas or the labor agreement. So we talk about the 482. In the 482, the requirement is that applicant needs to have minimum 2 years of an experience, has to have under the direct entry, and need to have 5 each in English for long term and 4.5 in English for short term visa holders, and can apply for this visa for 2 years or up to 4 years depending upon the occupation list that you are choosing. SBS is required. The SBS does not need to be approved at the time of the lodgement of the nomination or visa application. You can have an SBS or a nomination in process while you are lodging a visa, and so is the nomination. For a 186 visa, now the second one is a 186. This is the permanent residency. There are the 3 streams under the 186. You can apply for a 186 under the direct entry. The requirement of direct entry is you need to have 3 years of a full-time experience and a skills assessment and 6 each in English and be under the age of 45 years. and the occupation from the 186 legislation requirement. If you meet all of these ones, your employer is happy to sponsor you. You can apply for a 186 direct entry. You do not have to go onto the 482 visa necessarily to go onto the 186 if your occupation is from the list. There is no SBS requirement in a 186 visa. There is no LMT requirement where the employer must advertise the position, though we say that employer should advertise before nominating or before offering the employment to the local candidate to meet the genuine requirement of the position. The second type of a 186 visa is the TRT, which is the transitional resident stream, where it goes through where the applicant has worked for the current employer as a holder of 482 visa for 3 years. This is going to the requirement is going to reduce to 2 years from December onwards, and your visa can be under the short-term stream or you have got it from under the long-term stream. It doesn't matter. Now, both of them leads to the TRT. The age requirement, there is no exemption under the age requirement. You still need to meet the age for 45 years when you are lodging your 186 visa, either under the TRT or under the direct entry. For 186 under the labor agreement, the age can be negotiated because what you have done under the labor agreement, you need to get it approved for a 482. When you're lodging a 482, you are going to get the negotiation done that at the time of the lodgement of a 186, the applicant can be 50, 55 and above, but that can only be negotiated under the labor agreement. Then the 494. Why there is a need for lodging a 494 is if the applicant wants to apply for the permanent residency, though 494 is a provisional residency and the occupation is not there on a 186 visa. So, since the day the department has announced that the applicants from a 482 visa after 2 years can apply for the 186 TRT, so the short-term visa holders especially, then there wasn't any PR pathway for them. So people were applying for a 494 in those cases. But now I don't see there's much need of lodging a 494 unless until your occupation is not there in a 482. Because in a 482, you can work with an employer for 2 years and can apply for the residency right after 2 years. Another difference between the TRT stream or which is the 191 or a 494 is that when you are applying for a 191 visa, you do not need your employer after the 3 years. You can apply for the permanent residency without the employer as long as you have met the condition of living in a regional area as well as working with your employer for the 3 years. You don't need your employer to sponsor you again. When you're doing a TRT, after 2 years, then you need your employer to sponsor you again, have to show that there is still a genuine requirement of a position. So that's where you have to gauge whether you want to go on to the 482 visa and then you need your employer again after 2 years to sponsor you for a 186 TRT, or you want to go on to the 494, work with that employer for 3 years, and then there's no need for the employer documentation or to sponsor you or to show the genuine need of the employment again. Other than the 482, 186 and 494, the next visa which we talk about was a training visa. This is specifically for the people who do not have much education or experience in their nominated occupation. Then they can apply. Their requirement is either to have the study completed within the last 2 years in the occupation where they are nominating or need to have a 1-year experience within the last 2 years. Then comes the DAMA. As I talk about, there is a DAMA under the labor agreement. The DAMA is under a labor agreement. You can apply for a DAMA under an industry specific where the skills, education, experience, English requirement, and the occupations have already been negotiated. There are different type of industry specific like a horticulture, there's a hospitality, there is aged care where the department has already negotiated the requirements of the applicant and then can apply under that stream. It is a quicker processing as compared to doing the labor agreement as a whole where you have to negotiate the education and experience. Then Dharma is also endorsement from from your local shire. These are also the education and experience which are already negotiated and can be applied. You need to have an endorsement from the local shire. Then the process is a labor agreement, then nomination and visa. The age, education, experience requirements, that's all negotiated already by the shire. So every uh, um, region has got their own requirements, have got their own list. So if you want to know whether your occupation is under the Dharma or not, you need to go into the region of that area and look for the shire and list of occupations for that region. So now these covers all of these, all the employer sponsored visas. And thank you so much. So if there's any questions, let me have a look in the chat room for this. There's a question from Vandana. Is it possible for the company to sponsor a 482 visa for its foreign director? Yes, there is a way that they could do the application for this one. This is the higher management positions, and this can be done. And the next question is from Ravi. Can we apply for the Dharma if we study Diploma of Early Childhood and Care? Yes, Ravi, if you can apply for the Dharma, for example, you are a childcare worker, then your requirement could be having a 1 year of an experience, or maybe just the certificate 3 in early childhood. If your region has got, because there are the Dharma in different regions, all of them have got a completely different requirements from each other in regards to their education and experience. Depending upon which region you are going into, you could go for. For example, the Pilbara region, their requirement is either have an Australian study or 1 year experience in your nominated occupation, which is the childcare educator. All right. So if you have got that one and you find an employer in the Dharma region, you can apply for this one. And if I don't see there's any more questions for this, thank you so much, everyone, for listening. Have a lovely day. Thanks.